A busy day in court. Two of Donald Trump's criminal cases, the Georgia election subversion case and the Mar-a-Lago classified documents case, face pivotal hearings today. So in Florida, a federal judge did not issue any rulings in a hearing regarding the classified documents case, nor did she make any formal scheduling moves regarding the trial date. Let's talk about Georgia. A judge there heard final arguments on whether Fulton County District Attorney Fani Willis should be removed from the Georgia election subversion case. This is after Trump and his co-defendants alleged Willis's romantic relationship with this guy you see right here has now created a conflict of interest. The judge declined to be able to make a ruling today and said a decision would come within the next 2 weeks. Lots to talk about. Let's bring in Queen City News chief legal correspondent Khalif Rhodes to be able to talk about this. One of the most explosive part of the closing arguments today came from Trump's attorney, who then brought up race and God.
Sato, he did an excellent job. I mean, if you are at home and you are wanting to go to law school, this is the case you need to be watching, because it's giving a master's class on how to do an oral argument, how to do a closing argument, how to use the rules of evidence. I mean, it's all unpacked in this very case. And so if any student is watching, seriously, go back and look at all of this. Regarding his evidence today, he said, look, there has to be either the actual conflict or the appearance of a conflict. And he laid out the foundation why there was an appearance. It seemed like he was very heavy on why there was appearance. There were 5 attorneys. The judge gave them 90+ minutes to do this. Then the prosecutor got out there and made his arguments. What I can say is not just the attorneys, but the judge. The judge was asking pointed questions at them, not showing that he made up his own mind, but wanted them to take him down the path of how their argument makes sense. Specifically, he asked the counsel for Trump, he said, well, have we ever done this before where there's just the appearance, not an actual conflict, but the appearance of a conflict? And nobody really had an argument for that. And so then when the prosecutor got up, he said, no, Your Honor, we haven't. The case law does not support that. That would be, I think, where the judge will rest his decision. Have you guys proved to me that there was an actual conflict? And do I have enough just for the appearance of a conflict?
All right, let's talk about what we saw in court. Today, you saw the charisma. You saw that from so many, too, that I can remember attorneys that really stood out. But then when you look at the district attorney, it kind of felt, it was kind of a lull for me.
They train the district attorneys across the country, and when they go to their DA conferences, to teach and to talk off of these PowerPoint presentations. And they do that for a number of reasons. You want to ensure that you don't miss anything, that when you're presenting in front of a jury, that you list all of the elements, all of the requirements that are needed for a person to be convicted right in front of them, so they can be up there on the billboard for a long time. Now, I can say they've been doing that for the last 20 to 30+ years since PowerPoint's been a big thing. But what I can tell you is that it kind of dumbs them down. It kind of shackles their hands and allows them to kind of be boxed in into one location, where you have a defense attorney that will stand up and kind of will just go. Not saying they're going off the cuff, but they're able to have a more free-flowing and fluid conversation. And that's what you were seeing. Sato and the other merchant, not the female, but the husband, he did an excellent job of just flowing with his argument. The judge wouldn't throw him off. You'd see the other attorney for the prosecutor side, when the judge would ask a question, he'd go back to his PowerPoints and then come back. That kind of throws a jury off, and they're not listening and kind of not paying attention. But because it's the trier of fact as a judge, the judge understands what he's doing, and he's able to follow the argument, so it won't hurt him. But it definitely wasn't compelling. It wasn't charismatic, and it wasn't something that had you captivated. It kind of was a snoozer, but he hit the points that he needed to hit.
I have 2 more questions for you, and I know we're slow on time. The first one is, what stood out for you? I mean, I know you're a defense attorney, so to me, I think that now I understand where you get all the charisma from. I get that part, but you know, it was explosive today. I mean, the points that were made, did it change anything?
No, I think the judge is genuinely still undecided, and that's what you want. You want to come into closing arguments with a chance. You want to be able to say, listen, Your Honor, we've had our case, we've had everybody testify, now at least hear me out today and then make a decision. The fact that he said, I need 2 weeks to dive into this, great point for at least the defense attorney, because he heard our argument. And now, did any of it resonate? I think Sato made some arguments that may have resonated with him. But even if she's dismissed, as I end on this point, that case doesn't disappear. The Georgia law says a new prosecutor will be selected by a panel. And so even if Willis is removed, the case will continue.
Real quick to get this in, if Willis is not removed from this case, what happens next? Do you think this case can really play out now that the court of public opinion has now joined in?
One thing the law has a stern obligation is to avoid what the court of public opinion says. A judicial official has an obligation to disregard that and continue doing the law of the court. And so the business of the court is set a trial date and keep this moving.
Khalif Rhodes, we appreciate it. Thank you so much.